Hey people, it's NIyas talking. Now this is from Forbes. The Supreme Court will decide whether police can enter a home to seize guns without a warrant. The Fourth Amendment right against warrantless searches of a person's home is a pillar of Americans' constitutional liberties. Before a police officer or any other government official can enter your home, they must show a judge that they have probable cause that they will discover specific evidence of a crime. I just want to stop something. This guy, the writer, Evan Gersman, says, I am a professor and publish on constitutional education issues. If you actually read The New Jim Crow, you would actually have realized that the Fourth Amendment has been already eviscerated. You just have to, all that stuff goes out the window and say, I smell drugs, and that's all you need to violate someone's rights, especially if they're black. But let's keep going. There are some limited exceptions to this right. There is an exigent circumstances exception. If a police officer looks through a home window and sees a person about to stab another person, the officer can burst through the door to prevent the attack. There is also the emergency aid exception. If the officer looked through the same window and saw the resident collapsing from an apparent heart attack, the officer could run into the house to administer aid. Neither of these cases violate the Fourth Amendment, and few would argue that it should be otherwise. Again, but this begs the question, why is he looking in people's windows? Was he able to see it from the street, or did he walk up to it? Was he looking in there hoping to find something? Anyway, let's keep going. However, there is a broader cousin to these amendments called the community caretaking exception. It originally derives from a case in which the police took a gun out of the trunk of an impounded vehicle without first obtaining a warrant. The Supreme Court held that there is a community caretaking exception to the Fourth Amendment's warrant requirement because police perform community caretaking functions, totally divorced from the detection... Community caretaking functions divorced from the detection, investigation, or acquisition of events related to the violation of a criminal statute. Again, this is why I don't really like this whole thing about the law is the law. For those of you who follow me, I've said that there have been many cases that have gone before the Supreme Court and other courts that have ruled that the police have no other job apart from investigating and upholding the law. That's it. They do not have an obligation to protect individuals. Now, of course, this law professor, which I really doubt because they don't seem to know any of these cases that I'm referencing. I'm going to look them up at the end. But they go on about these... that they have the community caretaking, yet the police are not obligated to protect anyone. The court held that the police activity and furtherance of these functions do not violate the Fourth Amendment as long as it's executed in a reasonable manner, and it will be decided by the police. Note that unlike the first two exceptions, this exception is not limited to immediate emergencies. In the Supreme Court case just described, there was only a general concern that vandals might eventually break into the impounded car and steal any weapons that were in the trunk. So the community care exception is far broader than the other two. Also, all three exceptions allow warrantless searches so long as the police officer acted reasonably. That is one of the easiest constitutional standards to meet and a significantly lower standard than probable cause, which is required for a warrant. As long as an officer might reasonably think that a warrantless search will alleviate a danger to the community, a search is considered constitutional. This is a vigorous debate about whether the community care exception can apply to searches of a person's home as well as their car. Vehicles have always had less Fourth Amendment protection than homes, which are considered a person's most private sphere. Federal courts have been divided on this question, and the Supreme Court has not ruled on it until now. The court has just announced that it will hear arguments next month on a case that presents this issue. Caniglia v. Strom. In this case, Mr. Caniglia was arguing with his wife and melodramatically put an unloaded gun on the table and said, "Shoot me now and get it over with." His wife called a non-emergency number for the police, who arrived shortly thereafter. The police disagreed about whether Mr. Caniglia was acting normal or agitated, but they convinced him to take an ambulance to the local hospital for evaluation. The police did not accompany him. While he was on his way to the hospital, Mrs. Caniglia told the police that her husband kept 2 handguns in the house. The police decided to search his home for the guns without obtaining a warrant. Mrs. Caniglia's consent to how the police searched the home was legally negated because the police untruthfully told her that her husband had consented to the seizure of any guns. The police located and seized the 2 guns. Mr. Caniglia sued for the violation of his Fourth Amendment right to privacy and his Second Amendment right to keep handguns in his home for self-protection. The First Circuit Court of Appeals, which is the federal court just below the Supreme Court in Caniglia's jurisdiction, side of the police. So basically, lying is to a person to violate their rights is upheld by the Constitution. The court wrote, at its core, the community caretaking doctrine is designed to give police elbow room to take appropriate action when unforeseen circumstances present some transient hazard that requires immediate attention. Understanding the core purpose of the doctrine leads inexorably to the conclusion that it should not be limited to the motor vehicle context. First, the individual and community safety are not confined to the highways. It is certainly true that police need a good deal of discretion in carrying out their varied, complex, and sometimes dangerous duties. They are also powerful agents of the government, and the power is supposed to be restrained by the Bill of Rights. The Fourth Amendment is supposed to protect the home above all other places, and whatever one's views on gun control may be, the Supreme Court has clearly held the right to keep handguns in the home is at the core of the Second Amendment. Unlike the exigent circumstance and emergency aid exceptions, the community caretaking exception is not limited to circumstance where there is no time to apply for a warrant. And the question of what sort of caretaking falls under this exception is extremely vague. Will the police be able to use it to, for example, conduct warrantless searches of political protesters' home to make sure they aren't planning on violent behavior at their next political rally? Yes, only the police can do violent behavior at protests. The Supreme Court is going to take a very close look at this case, and there's a good chance that it will overrule the lower court's decision. Anyway, I'm going to look up those other court cases I was talking about, in which the several courts ruled that the police only have an obligation to uphold the law, not protect people. I'm going to leave this article in the description. Please comment, rate, share, and subscribe. I'll leave my GoFundMe in the description. If you want to follow me on Instagram, I'll leave it there as well. If you'd like to buy one of my t-shirts, I'll leave it there as well. Peace.